YouTube, so I'm going to make a video on judicial precedent. I'm sorry if you hear my brothers in the background, they are way too noisy. Hopefully they will stay quiet for the duration of this video. Okay, so a bit of background. Parliament makes legislation. Judges apply and interpret the legislation when a dispute is before them at court, and when judges apply and interpret legislation, they create a legal precedent. So the doctrine of judicial precedent, or stare decisis, means to stand by what has been decided. Legal principles made by judges in higher courts bind lower courts in future cases with similar facts. For the doctrine of judicial precedent to run smoothly, three things are required: a ratio decidendi, a settled court structure, and accurate records of the decisions made by higher courts. So ratio is the reason for deciding. It's the legal principle that the court uses to make its decision, and in their judgment it is the legal reason which forms part of the ratio. The ratio is binding precedent, meaning the judgment is binding in future on courts of the same level and all courts below. So case examples of ratio are in Howe, where the House of Lords held the defendant was guilty of murder because the defence of duress was not available to a defendant who is charged with murder. And in Brown, the defendants were found guilty of offences under section 47 and 20 of the Offences Against the Person Act 1861. They pleaded the defence of consent in respect of their sadomasochistic practices at a private party, but this defence wasn't available to the defendants. Another case example is Donahue and Stevenson, where the claimant went to a cafe with a friend and they got a ginger beer. And there was like a snail at the bottom of the ginger beer, and she suffered shock and gastroenteritis, and the House of Lords held that the manufacturers owe a duty of care to the ultimate consumers of their products. So the ratio in Donahue and Stevenson was original precedent, which judges can create when a new situation arises or where there is no existing precedent or legislation. However, judges rarely make it clear what the ratio of their decision is, so it's up to lawyers and judges reading the judgment to find out what the ratio is. Obiter dicta is other things said. It's not crucial to the outcome of the case. The judge may discuss matters other than the ratio in their judgment. For example, what would the outcome have been if facts of the case had been slightly different? An obiter can, however, be persuasive, as seen in the cases of Howe and Gott. So, in Howe, the ratio was that duress is not a defence to murder, and the obiter was that duress isn't an offence to attempted murder. And in Gott, there was a case where the defendant was charged with attempted murder and he pleaded duress offence. The court followed the obiter dicta in Howe and found the defendant guilty, so the obiter in Howe, that duress isn't a defence to attempted murder, became the ratio in this case. So, precedent can be either binding or persuasive. Binding precedent is ratio and it must be followed. Persuasive precedent is a precedent which may be followed, for example, obiter, decisions in lower courts, decisions in Scottish courts and other Commonwealth courts, or decisions of the Judicial Committee of the Privy Council. Also dissenting judgments, which is the decisions of minority judges. So, in the case R&R, the Court of Appeal in the House of Lords followed a previous Scottish decision that a man can be guilty of raping his wife. And in Candler and Crane Christmas, Lord Denning was a dissenting judge and expressed the opinion that a person who suffers financial loss as a result of negligent misstatement ought to be able to recover damages. So Lord Denning's dissent in judgment was followed in Headley, Byrne and Heller, and now forms the basis of the law on negligent misstatement. So that is the first part of judicial precedent, and there will be more to come later. Hope you like this video. Don't forget to subscribe and like this video. Bye!